father's rights in divorce, custody, and family law issues with offices in Nutley and Montclair, New Jersey. Today is June 4th, 2019. As I said, this is in New Jersey. So what I'm talking about today, if you're listening at any other time or in any other state, you need to check to make sure the laws have not changed or that they apply in your jurisdiction if you're not in New Jersey. Today's video is my weekly how-to series where I discuss some topic a little more lengthy than I do with my daily topic, so I can give you some guidance into things that I find happen or confront my clients in many cases. Today's how-to series is how to know when you're losing your case in New Jersey. And I base this on things that I hear often and misconceptions I think that clients have going into cases. And I didn't call it misconceptions because I've done videos and webinars on that topic, and YouTube gets pissy when you have things that sound similar, so I had to call it something different. And I'm looking at different topics, so it's not really going to be the same material that I covered in the misconceptions, but they would be good videos and webinars to watch also, separate from that. But that's enough explaining. Let me jump into the tips. There's only 5 things I think that apply in this at least limited case. So how to know when you're losing your case in New Jersey. First is if you go in looking for justice. People will call it fairness. Some will say what I'm entitled to. There's no such thing as justice, fairness, or entitlement in New Jersey family or divorce court. And the reason is what you think is fair or just is not going to be what your adversary or your spouse thinks is fair and just. And certainly what the judge thinks is not likely most times to match up with that. So don't go in thinking about justice and fairness. Go in understanding what the bounds of the law will be, what the ranges of support of issues and outcomes may be, and that's what you should go in with the expectation, but not looking for justice or fairness. They're just broad topics and concepts that just don't exist. Second is believing that the judge cares about you and your case. And what I mean by that is not to suggest that judges don't care about their case, especially if there are any judges that are watching this. But a lot of people will say to me, I'm just going to go in and tell the judge my side of the story, or I'll show the judge my proofs and that'll be enough. It's not going to be enough, because it's not a question of how you tell your case. It's a question of the method, the proofs, your body language, the intonation, consistency. There's a lot of factors that go into it. It's not just simply telling the truth, which of course you need to do, but the judge isn't going to care about you any more than the other side. He or she's going to listen objectively to the proof and how it's presented. So don't think because you think that you're right, the judge is going to automatically agree with you. Big, big misconception. Third is listening to your friends or family. If you're going into court based on advice you're getting from your friends or family, unless your friends or family are me or an attorney, it's not going to be good advice. There is too much information out there for any one person to know who's not involved in the process what to expect. Friends and family try to be helpful. They will often give you horror stories. They will have heard different stories. Their story themselves may be entirely different, is likely to be entirely different, because everybody's case and facts are different. No one person can convey to you what to expect based on one thing that they may have experienced or something they may have heard from somebody else. It's not going to be helpful. It's not something you should ever rely on. Fourth is listening to the clerks in the courthouse. And when I say clerks, usually when you're calling one of the court offices, like the matrimonial part or the non-dissolution part in New Jersey, this is what we call them, and asking the people on the phone for advice. They are helpful and they try to do a good job, but more often than not, they do not know what they're talking about, and they are not allowed to give you legal advice of any kind, and many of them do. A lot of times because they don't realize what they're saying is legal advice. They think it's procedural. They think it's based on what they've known. It's not the case. They will often tell you, for instance, that you can or can't file something, or you can or can't ask a judge for some kind of relief in an application. They cannot make this decision. If they're telling you this, you need to speak with somebody that supervises them or go directly to a judge with what's called an order to show cause, because they're overstepping their boundaries. Technically, they're even committing a crime when they do that. Not really the relief I'm looking to encourage you to seek, but just so that you understand the severity of that advice. Last and not least is holding out for a trial. A lot of clients will say to me, well, I'll just wait to go to trial, or, I don't have anything to worry about. We'll just wait for the trial date to come. That's a mistake in many reasons. One, you don't know the outcome of what your trial is going to be. People have no idea, lawyers and clients, never know what a judge will focus on. You never know what a judge is going to decide or how they're going to interpret the facts. But even more importantly, the large majority of judges that I've experienced don't want to give you a trial. There's a lot of reasons why I'm not going to go into it, political and administrative, but let's just say my experience, very few judges give you a trial date until it's the absolute last solution, often much later than you would have expected or even were told by the court. When you do get a trial date, it's usually not a guaranteed date, which means you can spend all this time and money preparing, take off work, go there and find out that they're not giving you a trial date and you're sitting in the hallway talking. If you do have the good fortune of starting a trial on any given day the judge orders it, it is not likely to conclude that day, and you're not likely to have continuity in the days, meaning you'll come back in a month or two after your first day. So you may take an hour or two of testimony, come back in a couple months to take more testimony. It increases the cost astronomically because you go through all the preparation again. Facts are often forgotten by the judge and other members of the court. Sometimes you have witnesses that aren't available. It's a horrible mess. So if you're holding out thinking that going to trial is going to be in your best interest, it's probably not the case. So these 5 tips are the main ones that I experience with clients that are bad signs of how they're managing their case or looking at their future, which is why I say it's how you know you're losing your case. Obviously, it's not a guarantee, but it is just a way to open your eyes. I would encourage you to consider these things. If you find yourself saying this, or your adversary is saying it, or one of the attorneys in your case saying things like this, you know you have a problem if it's not you that's saying it also. So just keep your ears open for that. I hope this helps you. If it does, please give a like, share it, and subscribe so that other people get to see it. You can also put on notifications so that you'll get notified when I do go on and give these tips and webinars. With that, I'm going to sign off and hopefully see you soon.